Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos, we're talking about what needs to be done in order to come back to the United States after being deported. Now, one of the applications that needs to be done is called permission to reapply. So then the question becomes, what should you include in a permission to reapply? And numerically, this would also be referred to as a form I-212. Well, basically to ameliorate the harsh consequences of being deported for many years, the permission to reapply does give the government the authorization to grant a waiver of all of those years of waiting. So essentially, if it's granted, then instead of waiting 10 years or 20 years, that just disappears, and then you can go on to the other applications to come into the United States. So you have to not consider so much extreme hardship to any specific family member in a permission to reapply. Rather, the government will consider the following. Will consider your moral character, hopefully your good moral character, the need for your services in the United States, whether you were ignorant of the fact or didn't know of the fact that you actually had a deportation order before you were deported, the length of time that you had been in the United States, the reason that you were originally deported, and the hardships that were resulting from the deportation. And of course, then you can get into all the hardships of your family and so forth, but they do concentrate on you, on the hardships you will suffer, and then the recency of the removal order, any evidence that you have showing reformation and rehabilitation, and show your family's responsibilities and ties in the United States, and then show the existence of any approved immigrant visa petition for the applicant. Now, you understand that the permission to reapply is granted in the exercise of discretion, so they will balance the good factors with the bad factors. And of course, if you have lots of repeated and significant immigration violations, and whether you are inadmissible on some other ground of which there is no waiver, that of course would go against it. But do try to submit all of the above evidence as best you can in order to get an approval from the government. Okay, more on the coming videos.